if you have been following the immigration law space, you would know that this man requires no introduction. And for others, our guest is a veteran with close to 3 decades of experience in this space. He's currently a partner in Whiteman Osterman and Hanna, and also an adjunct professor in Albany Law School. A fun fact is you don't need to pardon Seth's French because he knows his line just well. This is my first AMA session that I'm hosting in Untitled, and it's my privilege to welcome Seth R. Leech. Hey Seth, how's it going?
Everything's going well. Thanks for the brief introduction, Arvind.
So the maximum concentration of a community is of members who are trying to apply for the O-1 and EB-1 visa. And you seem to have filed dozens of them over your course of career. Can you pinpoint and say one such case which was very interesting that you filed and got an approval for? Of course, you can hide the personal details and stuff, but we would be curious to know one interesting case.
So one thing that has been really interesting is the evolution of the O-1 visa and the ability to use O-1 for entrepreneurs and being able to piggyback on what the entrepreneur has developed in terms of a business to help support the O-1. So it may not be one case, but we've had several cases recently for individuals with very, very brand new businesses who have been able to use the creative idea of the business to demonstrate extraordinary ability. And again, as Arvind said, I can't really provide a lot of detail because of client confidentiality issues. But that has been kind of an exciting development, is being able to use the idea for the business as support for extraordinary ability in the O-1 context, but also in the EB-1 context as well.
Interesting. A follow-up to that, right? Probably this is more like a generic question, saying that what do you think you wish immigrants knew more about O-1? Like the fine prints about the O-1 visa in general, right? Which is not quite very, out there, but like the fine prints, what do you think our immigrants should be aware of?
So, I think anybody who is considering an O-1 or an EB-1 for that matter, because the criteria for both O-1 and EB-1 are similar, if not identical. One thing that I would recommend to anybody who is considering these types of visas is to review the USCIS policy manual. This is the roadmap that the U.S. government adjudicator is going to use when they make a decision on your O-1 or your EB-1. The USCIS policy manual on extraordinary ability is very accessible. It's user-friendly and lays out in very clear detail what the U.S. government is looking for in terms of evidence for O-1 and EB-1. So that, I think, would be a very good starting point and something that everybody should know if they're considering one of these visas.
So, Seth, you're one of the few lawyers in the country who has obtained, or rather successfully obtained, the IEP petition. Can you talk about what is IEP and your thoughts of using it for founders, right? What are your thoughts about it?
IEP, International Entrepreneur Program, was introduced from an idea standpoint the end of 2021, although it had its origins before that. The IEP, I find, in my practice, only helps the minority of my clients. Once again, there's a very good roadmap to what the IEP is and how it can be utilized on the U.S. government website. And I caution people not to pay a lot of attention to external websites, but always go to the U.S. government website. So IEP, the biggest challenge, the IEP is neither a non-immigrant visa, it's not like an H-1B or an O, and it's not an immigrant visa. It's a parole. It is a permission to be here to conduct a certain activity. It doesn't lead to a green card, and it has a lot of restrictions on it. So if there are other options available, I will typically pursue the other options before considering IEP. main problem that I have seen with IEP cases up to this point is what constitutes qualified investment. And the U.S. government has very, very strict rules on what is qualified investment for the purposes of IEP. The amount goes up from on an annual basis, and so it continues to increase. So if you're thinking about an amount wise, I would say try to target $300,000 at least, but keep an eye on that because that changes. But the qualified investment must come from U.S. investors, and those U.S. investors have to have a proven track record of successful investment in the past. And that is one of the things that is oftentimes a sticking point. A lot of information there, and I definitely would be willing to go into that in more detail if there are questions.
Super interesting on that. So just a follow-up question on that, right? So you're saying that if I were to just simplify down, I'm a founder, I've come to United States, I'm an immigrant myself, and let's say I have multiple options out there for me, right? If you're my attorney, how would you actually say that? Do you have a cookie cutter answer for all founders to follow a particular visa, or you kind of personalize it based on their journey? IEP versus O-1 or EB-1? Yeah.
It is very personalized because every founder, every experience is different. Every company has different different evidence that would come out of the company that may support one visa but not another. But it is difficult, if not impossible, to boil it down in a session like this and say, oh, you should do one thing over another. But what I have found is that the O-1 has been more of the go-to. It has been the prominent vehicle for founders to get, or entrepreneurs, others involved with startups to get a visa, a work visa to work for their company. That has been the primary vehicle. And beside that, there have been other options as well. Sometimes creative use of H-1B. We have done that on a number of occasions. How can you use an H-1B with a new company? Well, that's going to depend on the amount of ownership. It's going to depend on the relationship of the founder to their own company. It's going to depend on how much money is sitting in the new company. But there are a lot of creative options. Ranking them, O-1, H-1B would be my go-tos, followed by national interest waiver. That doesn't work a lot for Indians because national interest waiver is EB-2 and doesn't provide an immediate benefit, but perhaps EB-1, although those priority dates are backlogged right now. And then IEP. I met with someone the other day, which none of these other options worked for, and we will pursue IEP.
Yeah, I think that order kind of helped folks better understand. I have a question from Nirupama, is that for management consultants, who have highly client-facing kind of a role, there's no vertical advancement path, as in there's no straightforward as to which industry they work in. Pursuing an EB-1A category under an MNC manager criteria, what would be your suggestions in helping them solidify their profile? What are your thoughts on that, Seth?
What's not clear from this question, perhaps you can clarify for me. Are we speaking about EB-1A or are we speaking about EB-1C?
EB-1A category.
Okay, EB-1, and this is actually a super important topic.
Okay.
People need to come to attorneys and professionals early in the game because there's a lot of things that can be done early in the game that will benefit the individual at a later point when they're ready to file for something. So EB-1A, similar to O. So the advice is going to be very similar for both of these. Go ahead, try to get press and media about your work. That's an opportunity eligibility category of the EB-1A. People who are creative can find ways to have their work and their profiles featured in the press. Opportunity category. Another opportunity category is judge work. And that is something that, again, there are tons of hackathons out there. There are tons of entrepreneur, juried entrepreneur awards programs or conference opportunities to be a judge of the work of your peers. That is a clear opportunity category for EB-1A or for O-1. Start to put together a list of your letter writers. Get to know people and make that list. So when it comes time to do either one of these petitions, and theoretically, even this would be helpful for IEP, when it comes time to do any of these petitions, you'll have a list of letter writers that you can go to. Find out if there are selective organizations in your field, and many people will join Sigma Psi, which is a well-known organization, but that's more in the scientific realm. So if you're doing something that relates to science, to STEM, then maybe join Sigma Psi, and then you'll have a selective membership, which satisfies another of the eligibility categories. But
Understood.
Start to do these things from the beginning, and then when the time comes, you'll be ready.
Yeah, I think that kind of like start early. If that's the clear takeaway, I think that makes
Get advice early. Right.
Yeah, get advice early. What would be the same advice if the person is trying to pursue EB-1C, which is more like a multinational manager category? They are operating in multiple places. What would be your advice on how to solidify their profile? What do they need to do?
So EB-1C, unlike EB-1A, requires employment and requires an employer sponsor. And so you need to have worked with the company that is going to be doing the petition for you in the U.S. within the past 3 years abroad. So this requires that there is a foreign entity and that you will be transferring to its U.S. affiliate or wholly owned subsidiary. So there has to be that employment relationship. You have to have worked for the company abroad. In this situation, the primary way that this works is that an individual transfers to the U.S. on L-1A, which is the intracompany transferee visa for managers and executives. Typically, they remain in the United States for a period of time on L-1A and then apply for EB-1C. It's not as common for individuals to just be at the foreign entity and do this through consular processing. This is a big topic, so I'd be happy to field more questions on this if you'd like.
Yeah, cool. Moving on to the next question. So Bhavan Jason, I think he works as an AI researcher and he's planning to apply for EB-1B through his employer's firm. His question is the number of letter of references that he should gather. Do you have a count on that, Seth?
I'm smiling because I've been doing these cases. That's really where I started my career in 1995 doing a lot of these EB-1B outstanding researcher professors. And the recipe for success, the law does not require a specific number. But my recipe for success over the years is to try to get at least 8 letters of support from diverse sources. You can't just get 4 letters from the same source. Diversity in sources is going to be really critical. Length of the letter is not critical. And I recommend at least 8 letters, but certainly if an individual can get more, then it strengthens the petition more. But 8 is my foundation.
Okay, perfect. I think, Bhavan, hope you got that answer. Next question we have from Ashwin. Is there a minimum number of papers one should publish for EB-1A category? Again,
no.
Very broad question. Okay.
Yeah, and no, it's funny. Yesterday, in the context of another case, I was reviewing the EB-1A U.S. government's view and how they review these categories. And a single paper meets the threshold for this category. A single judging event meets the threshold. A single article about you in the press meets that threshold. Where things become a little bit more complicated is in the final merits determination that USCIS does. Do they feel that just having a single thing in each category shows that you have the required recognition? But a single article would be good enough.
Perfect. Yes, Ashwin, I hope that answers. Moving on to the next one. So Manoj, he works in the product management and in the software and technology space. His question is, have you helped product managers file for EB-1A? If yes, what criteria is accepted? Since authorship would be difficult because it usually involves research, so any recommendation for him who's working in this particular industry?
So in the past 2 to 3 years, I've been working with a lot of individuals who do not meet the typical kind of scientific categories that people working in science and engineering meet, which are, you would expect from scientists. You would expect publications, perhaps media, the judging work, etc. So there are other categories too that individuals can try to satisfy in order to meet the EB-1A or O-1 criteria. And a product manager, for example, may be able to meet the high remuneration category. So if you are a product manager who is highly successful in what you have done and you're being paid at a high level, a level that is higher than what the U.S. Department of Labor feels is the geographically specific salary for your region, then that is a way for a product manager to say, yeah, I'm prevailing wage is, let's say, $125, but you're making $250. Then you could say you meet that category. And that's a category that a lot of people in businesses or non-STEM professions can use to meet the EB-1A criteria. Another one is demonstrating what they call leading and critical role in a distinguished organization. So, hypothetically, you work for a well-known company and you have done something really major as a product manager. You have really increased the profitability of your product in an amazing way. You've helped the company surge forward. That's a category that you can possibly meet. Ultimately, though, you're going to have to show recognition beyond your company. But there are categories that people who are not scientists or engineers can meet to demonstrate EB-1A.
Awesome. That's a well-detailed answer. Next question is, the topic about press in general, having a mention in an international media have more weightage than having mention in a local media? Let's say an immigrant having a mention in a local newspaper, magazines, and tabloid versus getting a mention in an internationally recognized tabloid. Is there a difference in the weightage on that set?
Yes, they will certainly give them. They will certainly give more weight to something that is more recognized on an international level. So, for example, I'm working with a Russian guy the other day. He has one. He was mentioned in an article in a St. Petersburg, Russia newspaper. Okay, that's good. That's good. But he was also mentioned in a Forbes article. So the Forbes article is definitely going to be a stronger piece of evidence, even though the St. Petersburg article would meet the threshold. The Forbes article is something that's going to be considered in that final merits determination to determine whether this person truly has recognition and a claim in their field. So definitely, the larger, the more well-known the publication, the stronger the final merits determination of the case will be.
Again, Ashwin, I hope this answers your question. We have an interesting question from Kunal. Does the startup need to be in the same area as the academics that I've pursued? For example, Kunal is a software engineer who also invests in his real estate. His passion is in real estate. He wants to know, if I wanted to invest in real estate full-time and form a company in this space, while my background is in tech, is that accepted in the O-1A filing?
So you need to have some connection. So, for example, I have another client recently who we did an O-1 for, who has a PhD in mathematics, and he has published a lot of articles on certain algorithms, certain areas of mathematics. But then he opened up a grocery distribution company in a major city in the United States. So how do we deal with that? What I did is, well, I delved in deeply to this grocery distribution company, and it turns out that he's using a lot of GIS technologies to make his grocery distribution company stronger. And it turns out that GIS is the technology that he's been developing for his grocery company requires a strong mathematics background. And so we were able to connect things that way. So you should, in order to be able to use a piece of evidence for either O-1 or EB-1A, you are going to need to connect that somehow to the venture. So maybe I guess it was Ashwin here who is thinking about doing this. If you could say, well, yes, I'm picking out my real estate investments based on a technology or algorithm that I developed, which helps identify areas of distressed real estate but are up and coming or maybe up and coming in the next 5 years, well, then, yes, you could use it. But there needs to be a connection, or you should work to try to make that connection.
Lovely. I love that how you had a case study approach to this answer. I really like that. We have Hitesh asking a question. I applied for my O-1A in May and I've received an RFE and currently working on preparing a reply. I just graduated from a business school in May and have my OPT as an option, which I've yet to apply for. What are my options to keep working on my company if my O-1A doesn't go through, and how can I use OPT in this particular case?
Well, if you have not applied for OPT yet, you need to do that. I mean, there's nothing inconsistent about applying for OPT right now while you have this O-1 pending. And I would also be OPT. This is actually a very broad topic as well. We could spend 2 hours talking about this particular topic. But you need to check, even if you graduated from a business program, is this a STEM OPT? Because some business degrees are now STEM, which would then allow you to get 3 years of OPT as opposed to 1. So that's something that you need to check in on. OPT does allow individuals to pursue their own business ideas, and without falling out of status or without failure to comply with OPT regulations. So pursuing your own business is something that you can do on OPT, but there are a plethora of rules around that as well. But in general, yes, you can. I know that's a short answer, but I know we're limited on time.
Perfect. Okay, on to the next question. Can I open a company during the H-1B grace period? And if I switch to some other visa, let's say the B-1 or F-1, would it be a problem that she should be aware of from the legal perspective?
So you're on a visa with another company and you want to open your own company. This is generally permissible, but you need to be careful because you fail to comply with your status or you're working without authorization if you're actually doing the business of the company. So, for example, you've developed a new software. No problem at all doing that. No problem setting up the company. No problem going out and seeking investors. No problem in finding future customers for that company. But when you get to the point that the company is starting to have revenue, it's revenue positive, and there is a need for a software programmer at your company or a computer systems engineer at your company, you can't do that work. You cannot do the productive work of the company of an employee that would typically be someone you would hire without having specific work authorization for that. And again, this is a complicated issue as well.
Perfect. I'm going to club Justin's second question and Akshay's question. Can someone pursue their own company or a startup while they're still in school, which is they are in their F1 visa? Is that possible?
Yes, and what I just said with the last answer is also true here. You can you can develop your product, you can incorporate, you can seek investment, you can seek potential future customers, and you can do all of these things while you are on an F1. You can do it while you're on a B1. You could do it when you're on an H1B with another company. But there is a line that you cannot cross, and that line is where you are doing the productive work of a revenue positive company, and that you're basically occupying a role that someone in the U.S. workforce would occupy, and then that becomes work without authorization. So there is a line that cannot be crossed, but all of those things I mentioned are acceptable. You could do those on any visa status.
Perfect. And I presume that line is different for each and every industry where they're trying to establish their firm, correct?
Yes, this is definitely something that individuals should get individual consulting on, because that line is going to be different. It is a gray area. The law has a lot of gray area here. That needs to be addressed separately for each individual company or venture.
Perfect. Speaking of consulting, like you mentioned, I think we have reached the end of the AMA session. So Seth has been gracious enough to join the community where we have listed him as an expert under the immigration lawyer space, something which we'll be opening up. So Seth is a busy lawyer, like I mentioned in my introduction, but he's been gracious enough to open up few free slots where you can email him about your profile. And there's a structure that we are mentioning, and Seth would be happy to do a free preliminary consult for that. And anything follow up, you can schedule a time with him and you can get down that route. But thank you, Seth, for doing that. And folks, you can definitely get your question answered on that.
Very good. It's been a pleasure.